Hi, I'm Peter Afrasiabi. The program you're about to watch, Ford Ferrari, where cars find IP protection in trade dress or don't. It was recorded a few years ago, but I've confirmed that the content is still current and reflects the present state of the law on this topic. Feel free to contact me if you have any questions or would like more information about any of the topics I cover in the program. I hope you enjoy it. Hello, I'm Peter Afrasiabi, a partner at 1LLP, an intellectual property law firm in Newport Beach and Beverly Hills, California. And today's program is Ford and Ferrari, where cars and autos can find intellectual property protection in trade dress law, or perhaps where they don't. Now I'll tell you, this program is built out of personal experience litigating a few cases in the auto space involving trade dress. And trade dress is the place that many auto companies, both first-party auto manufacturers, but also third-party companies that make auto parts. Trade dress is the body of law that they often go to deal with protection over particular car parts or cars themselves in terms of the design. So today's program will be a fantastic walk through trade dress law for those of you who are not familiar with trade dress, which is really a subspecies of trademark law. Our first slide, as you can see, is our fundamental question here today. Who's going to win the trade dress war in this Ford versus Ferrari battle? Is it the Ford Shelby Cobra you see there, or is it the Ferrari Testarossa? Hint, I'll give you the hint right now. Like the real race from history, we actually do have a winner here. So this one's not going to be a draw. One of these car companies and one of these cars is going to win the trade dress law in the federal courts. One is going to lose it. So stay tuned and watch as we get through this program to figure out who wins, Ford or Ferrari. So here's our overview. And the fundamental overview here is the issue of where cars and automobiles collide with the law. Trade dress law and trade dress principles are a species of trademark law. And we're going to look at an overview of trademark law to back into this. We're going to look at what's specifically important for trade dress, which is functionality, and what's also important to trade dress but also trademark, and that is secondary meaning and likelihood of confusion. And then we're going to look at an application of these trademark trade dress principles to various automobiles and see where there is and where there is not auto protection in shapes and of parts of cars and even cars themselves. So we're going to have a fun day today as we look at the following cars. We're going to look at Hummers, Vipers, Bentleys, and we're going to look at the Ferrari Testarossa and the Ford Shelby Cobra. And of course, we're going to have a final pit stop here on Lamborghini and Porsche, who have to get in on the action if we're going to be talking about cool cars and trade dress law today. So let's start with what is trade dress. Trade dress is the design and shape of materials in which a product is packaged. And so it's sort of the overall design and appearance of a product or product packaging, together with these elements that make up the overall image that serves to identify the product presented to the consumer. And so this will actually include retail stores or websites. And as you see here on this slide, we have the Coca-Cola bottle, that famous shape of the bottle. That shape of that bottle has trade dress protection as being the packaging for the Coca-Cola that we drink, but the packaging itself in the shape of the bottle is source identifying of Coca-Cola, and so it is an example of trade dress. Another example of trade dress that's found protection in the law are sort of even prescription pills, as you can see, that are in particular colors and the caplet shape and all that. That shaping and color scheme has found protection. And then we actually have restaurants. There you see a picture of the Fuddruckers restaurant, and that's a famous Ninth Circuit case that found a whole litany of look and feel elements from inside Fuddruckers. The white tile, the dark ceiling, the menu in a particular color combination, the lights of a certain kind, etc., garnered trade dress protection so that that combination of elements became source identifying so that someone else couldn't open a restaurant that looked the same inside, the same look and feel, with a different name. And then finally, we even have websites. And there we have the website from a relatively recent case of the Ingrid and Isabel Baby website. And they sued a defendant, and they survived summary judgment with claims that they had trade dress in their website look and feel. And the look and feel of the website meant the logo, and this is how the court defined it, the logo in a feminine script in pastel pink in the upper left corner, the pink and orange script carried throughout the site, There were close-up model photos featured from head to mid-thigh wearing white tank tops with jeans, long natural wavy hair. You had model photos instead of product photos. You had the color and pattern of the wallpapers in the background. You had particular category sliders. There were dots for the category sliders and similar colors on the dots. The placement of the models next to them, the fonts used, how the models were posing. All of those elements taken together could constitute trade dress, which evoked a look and feel of that particular brand to the consuming public, meaning a competitor couldn't adopt the exact same look and feel and schemology on the website. So that is what trade dress is. The next question is, where does trade dress come from? Well, trade dress comes from the Lanham Act, and this is the federal Lanham Act at 15 U.S.C. 1125A, and it provides that any person who, on or in connection with any goods or services or any container for goods, uses in commerce any word, term, name, symbol or device, or any combination thereof, or any false designation of origin, false or misleading description of fact, or false or misleading representation of fact, blah, 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 is ultimately liable potentially for trademark infringement or trade dress infringement. And so trade dress as protected product packaging or product design comes out of this idea that symbols or devices and elements of them can garner what is trademark protection for companies and prevent against consumer confusion. So the Lanham Act, on our next bullet point here, we can see, defines the universe of things that can qualify as a trademark in, quote, the broadest terms. And this comes from the Qualitex U.S. Supreme Court case. And so in the broadest terms, anything that human beings might use that is capable of carrying meaning as a symbol or device can be trade dress. Hence, websites and even in the interiors of restaurants. The Lanham Act, and this comes from the 2 Pesos case from the U.S. Supreme Court, the Lanham Act is intended to make actionable the deceptive and misleading use of marks and to protect persons engaged in commerce against unfair competition. So fundamentally, trade dress creates a visual impression which functions like a word trademark. So the same way you may see the Nike swoosh or the word Nike, and that conveys something to you. You know the source, the origin, the quality, the goodwill, whatever the value is in Nike, you see it and you're aware of it because of their trademark in the name Nike or the swoosh or Adidas and the 3 stripes, for example. Well, the same is true for trade dress in that certain trade dress immediately connotes to you, the consumer, the same source of that product and the same goodwill that may be existing or inhering in that product. In that sense, trade dress is a species of trademark law. So let's ask on our next slide the first question, which is there a registration requirement? In order for you and your small business, or if you're a transactional lawyer watching this and your clients come to you and they have a small business and they're trying to get protection for it, they may want to know, do we have to register in order to have trade dress? And the answer is no. Now, there are consequences to not registering, because if you proceed with a lawsuit to sue someone who's using the same product packaging or product design as you, and you're suing on an unregistered form of trade dress, then you'll have additional litigation hurdles you have to get over. So there is value in registering with the U.S. Patent Trademark Office in order to register that trade dress. You'll find benefits in litigation later. The flip side, of course, and this is why you find in many, many, many litigated trade dress cases, they are litigated by plaintiffs with unregistered trade dress, by very, very sophisticated plaintiffs with legions of in-house lawyers. And so that your first question may be, why don't they ever register? The reason, and this is just my opinion, but the reason I think many, many lawyers are reluctant to try to register trade dress is for fear of it being rejected by the patent office, because if it gets rejected, you can never go after a defendant on a trade dress claim, because you'll be forever out of luck having tried and been told by the patent office that you lack trade dress rights. And so because registration isn't required to sue and doesn't even garner additional remedies or remedial benefits, ultimately, the additional hurdles you have to get over in litigation can make it so that companies don't register. Now, that said, many large companies also do register, but there's a very significant tactical issue to keep in mind when you're representing smaller businesses and companies who have successful product packaging or design, they have to think tactically about whether they do want to register or not. The contra is in patent and copyright law that we'll just take a little pause here and mention, and that is to have a patent, of course, there's an absolute registration requirement. You do not even have a patent until the United States Patent and Trademark Office actually issues you a patent on your claims and your invention. And so it's a per se registration requirement in that sense. Copyright, on the other hand, if you've watched any of my copyright programs, you'll know copyright does not have a registration requirement. Your copyright exists at the moment you fix in a tangible medium your original expression. But in order to sue someone for copyright infringement, you have to register your copyright in order to have even standing to file a lawsuit. And that's a significant new wrinkle in the law from the US Supreme Court in the 2018 decision called Fourth Estate, requiring an actual issued registration to even file a lawsuit. So it used to be you could have an application pending and sue. Now you have to have a registration. So in copyright, there's a huge benefit to registering right away if you ever think you're going to be litigating it, so that you have your registration and you can go right to court if you need to. Well, let's pivot back on our next slide to trade dress, and here we can see these are the elements a plaintiff has to show in order to claim trade dress. To state a claim for trade dress infringement, a plaintiff must show that its trade dress is non-functional. That's number one. Number two is either inherently distinctive or has acquired a secondary meaning. And number three is likely to be confused with the competing trade dress by members of the consuming public. What I want to do now is walk through these three elements. And so let's talk about the first one, and that is the proof that this trade dress is not functional. And this is the plaintiff's burden to show that trade dress is not functional. Certainly in the Ninth Circuit. There may be a split in some circuits, or at least in some district courts and other circuits, as to who bears a burden on non-functionality. But the proper, I think, reading of the case law on this is that it's the plaintiff's burden to establish that its trade dress is not functional. And so this means that the product packaging and design of your product packaging or product design must be non-functional. If it is functional in nature, then the Lanham Act cannot protect a party. And in other words, what the courts have said is that if you have something that is entirely functional in nature, you need to go to the patent laws and to the patent process to get a patent on your functional product, because patent law protects new, novel, non-obvious functional creations. And this is very, very important for a significant reason. If you have something that's functional, the courts will allow you to have a patent on it. But the quid pro quo for that monopoly that you get via your patent is a limited duration. So in 20 years, you no longer have a monopoly on that, and other people can make similar functional products. Here's the big thing about trademarks. Trademarks live forever. So long as you are still using that trademark, the trademark never dies. So this is why courts are very concerned about not allowing functional product design to get what is effectively a permanent monopoly beyond the patent 20-year monopoly, a permanent monopoly through the back door of the Lanham Act. And so courts have to be very, very careful at this. And you as a plaintiff, if you're pursuing this, you want to be very focused on this issue of functionality, and a defendant defending these cases has a very strong incentive to push and present these cases as ones of backdoor patents and abuses of the Lanham Act for things that are really functional. And so the earliest and most fevered battles in trade dress litigation are over the functionality of the alleged trade dress. So how do courts figure out if something's functional? Well, as you can see on the next slide, here are the factors the courts look at to assess functionality. The first one is whether the design yields a utilitarian advantage. If it does, that weighs in favor of a functionality finding. Number two, are alternative designs available? If there are actually no alternative designs available to achieve this product design or packaging, then it is likely functional. Number three, whether advertising touts the utilitarian advantages of the design. So in other words, we're looking at how does the plaintiff actually advertise and treat this product design in its own advertising and commerce. And so here is a good practice pointer if you are likely to be a plaintiff on your trade dress, you want to be very cognizant of how you advertise your product. The tendency is to advertise even things that are arguably non-functional. The tendency is to use functional-based advertising to tout the functional advantages for the consuming public. And you have to recognize that if you have what you believe is trade dress and you advertise it in functional terms, that can be a boomerang that comes back to haunt you. So you need to be aware of that in terms of the use of advertising and how it can damage your claim to trade dress rights. The fourth factor is whether the particular design results from a comparatively simple or inexpensive method of manufacture. And what this is getting at is looking at a product feature as functional if it's fundamentally essential to the use or purpose of the article. And this is important because if the way a product feature exists is such that it is simply essential to be able to even use that article or that purpose of that article, then it counsels in favor of finding a functionality, because otherwise you would fundamentally put everyone at a competitive disadvantage in terms of being unable to make basic products to achieve certain functions. So let's take a look at some examples here. These are all from the Ninth Circuit. These are all published decisions that have rejected on functionality grounds various products. The first one is the Seacult case, 668 F. 3rd 677 from 2012, and it's a traction hoist, and this is used in external suspension bridges for commercial projects, and basically it's a hoist used to create those kind of walkways that you may see around buildings, for example, when commercial projects are being done. And the plaintiff there claimed that their hoist, they had trade dress rights in it because of its sort of the way its look and the way it's the look and feel of that actual product. The defendant made one that was identical, and the plaintiff said, no, you're effectively chiseling into my business and stealing my business with the same product, and people think it's us when it's not us, and you don't have the right to make it that way. You got to make it different. Plaintiff lost, and the courts concluded, nope, that product is functional. Second one is a similar fact pattern in terms of plaintiff and defendant companies making identical products, and the plaintiff being frustrated that they had here what is a webbing cutter used to sort of cut webbing and whatnot. Is that you can see that specialized device there, and the defendant made one that was identical. And the plaintiff said, well, look, you could make it in a different way, etc. But the court said, no, it doesn't matter. The defendant doesn't have to make it in a different way. At the end of the day, your product is functional. And in each of these cases, the courts ran through those four elements we just spoke about and did the functionality analysis and concluded in all of them that fundamentally these products were functional. And part of it, in the opinions when you read them, you'll see they were heavily focused on the advertising and how the plaintiff touted its own products. And these types of products are touted in what is essentially entirely functional ways. And so the plaintiff's own advertising of them being functional came back to haunt them when they were in litigation trying to make the claim that the products were not functional. Finally, we have the Leatherman case, and this goes back to 1999 from the Ninth Circuit, 199 F. 3rd 1009. And here it's a pocket tool. It's sort of a more complicated version of a Swiss Army knife, so to speak. But you've all seen them with the needle nose pliers and the scissors and whatnot in them. And they fold up and loop around, and it's like a Swiss Army knife, basically. All of these are made by all range of different companies. And there again, the court said that even if you may have been the first to create this kind of a pocket tool that had these additional tools in it, it's entirely functional. And so, as you can see, in these cases from the Ninth Circuit are not aberrational. There's a near wall of authority in the Ninth Circuit rejecting products on functionality grounds. It's actually very hard to find a published Ninth Circuit opinion that has said product design is susceptible to trade dress protection as being non-functional. You just don't see many cases that say that. The second element then is our issue of inherently distinctive or secondary meaning. And what this gets at is that trade dress and trademarks are protected if they're inherently distinctive or they've acquired secondary meaning. And if you're in on unregistered trade dress, you always have to prove secondary meaning. That's sort of the burden to the unregistered trade dress plaintiff. So what does inherently distinctive mean? As a kind of a recap for trademark law, what it means is that inherently distinctive marks are fundamentally ones that are suggestive, arbitrary, or fanciful. And what it means is, by definition, they identify a particular source or product just by virtue of the mark itself. So you think Google, the way we associate it with search, or the Nike swoosh with sports shoes and apparel. Those, the moment you see them, they automatically connote the brand or the source, and they're not remotely descriptive. I mean, Google and search, there's no connection whatsoever. The Nike swoosh and shoes, there's no connection whatsoever, other than the fact that these arbitrary words or marks have come to associate in the minds of consumers a particular source that stands behind them. So those are always inherently distinctive, and the same is true with trade dress. If your trade dress is inherently distinctive, then you've met that requirement. You just have to show secondary meaning if it's unregistered. What is not inherently distinctive, though, is a generic trademark or trade dress, and that's simply because it's not capable of having protection because it simply refers to a genus to which a product is a species. And so you could think family law. Family law is just a generic statement of, being a family lawyer, for example. And so you wouldn't be able to get a trademark if you opened up a family law practice and hung out your shingle and called it family law. And you couldn't stop the next person down the street when they open a practice and call it family law also. Now, descriptive is in this middle category, and these are marks that themselves are not inherently distinctive out of the gate because they really describe the product or service, but they could become descriptive, they could develop inherent distinctiveness over time and cease to be entirely descriptive because they've been used in a particular way for a sufficient amount of time that what attaches is called secondary meaning, such that consumers now see this descriptive mark as actually associating a particular source because even though it's descriptive, it's been used long enough that people now associate a source with the description. But let's be clear about trade dress, and this comes from the Walmart case. If trade dress is being claimed in a product design, you always have to show secondary meaning because product design can never be inherently distinctive. Courts demand secondary meaning, showing consumers have absolutely associated this particular design with a source. Because otherwise you have competition being deterred by even a threat of a lawsuit. And this is something that has caused the Supreme Court in the Walmart case there to have great concern. So what does it mean how do we get secondary meaning? On our next slide, as you can see, what exactly does this mean and how do we get there? Well, secondary meaning refers to proof that you have to give the court, the trier of fact, that this non-inherently distinctive trade dress has become distinctive as applied to your goods or services in commerce. And so the rationale for this is that a term which is descriptive may, through use by one producer with reference to his product, acquire special significance so that the consuming public, to them, the word has come to mean that the product is produced by that manufacturer. The crux of secondary meaning is that the mark being used, either the trademark, the word mark, or the trade dress, comes to identify not only the goods, but also the source of those goods. To establish secondary meaning, you have to show that the primary significance of the term or the trade dress in the minds of the consuming public is not the product itself, but the producer, the company that stands behind it, or a company. The company can be anonymous. Consumers often buy goods without knowing the technical exact owner or producer of the actual company, but they must understand that what stands behind this is a producer, and that's the primary significance in the consuming public's mind. So how do we show secondary meaning? On our next slide, you can see 6 different ways that we generate proof of secondary meaning of trade dress. The first is whether the people who produce the product or service that bears the claimed trademark, or trade dress, associate it with the owner of the product being made. The second is to what degree and in what manner the owner may have advertised under the claimed trade dress or trademark. The third is whether the owner has successfully used this trademark to increase the sales of the product, and this is all shown by evidence. The length of time is the fourth factor, and the manner in which this claimed trade dress is being used. Number 5 is whether the use has been exclusive or non-exclusive. Number 6, we look to whether the defendant actually intentionally copied the plaintiff's trade dress. If they did, that tends to show that secondary meaning has attached to this trade dress. The theory being the defendant copied it for a reason. They copied it because they knew that by copying it, they were going to plug into someone else's goodwill and therefore divert and steal away sales, basically. All right, so here on our next slide, you can see some examples of just descriptive marks that have ultimately been found to have secondary meaning by courts. And the one seminal one here is from the case of the Dallas Cowboy Cheerleaders versus the Pussycat Cinema Limited Company. And this is reported at 467 F Sup 366 out of the Southern District of New York in 1979. And the basic fact pattern there is, in a pornographic film, they used the Dallas Cowboy Cheerleader costume, and the Dallas Cowboy Cheerleader sued to say, you cannot use that costume because that costume is our trade dress. It's associated with the Dallas Cowboy Cheerleaders. And you are now associating it with a pornographic film, and we didn't give you the authority to use that to create the perception in the consuming public's mind that somehow the Dallas Cowboys may have, Dallas Cowboy Cheerleaders may have agreed to or consented to this sort of use in a pornographic film. And the court concluded that the Dallas Cowboy Cheerleader costume was fundamentally descriptive at some level, but it had developed over time secondary meanings such that white shorts, a blue shirt, and some stars over a vest and whatnot, those elements that would otherwise simply just be a sort of a cheerleader costume had become associated in the consuming public's mind with a particular source. And because of that, trade dress rights attached to the costume, and it was protected. The third element is likelihood of confusion, and this is the crux of all trade dress cases and all trademark cases too. And here courts look to, in the Ninth Circuit, there are these 8 factors with some additional factors if you're talking about internet products and services, but fundamentally the root 8 factors come from the seminal case from 1979 of AMF versus Sleekcraft at 599 F. 2nd 341. They're known as the Sleekcraft factors. Other circuits have a very, very similar, if not identical, test based on their circuit's jurisprudence. But you look to the following 8 factors. The first, in order to establish whether there's likelihood of confusion, is the strength of the plaintiff's mark. How strong a mark is this? So if we're on that spectrum, if it's descriptive, it's not very strong a mark. If it's suggestive, that's better, and that's a good mark. But if you want to have a really strong mark, you want to be just arbitrary or fanciful, something that's just completely arbitrary to the product or service so that you can show it's a very, very strong mark. So that spectrum we talked about, you want to be further up the spectrum if you're a plaintiff. Number 2, the proximity of the goods or services. In other words, how close are the defendant's goods or services to the plaintiff's? Are they selling the same basic goods or services, or are they not? Number 3, the similarity of the marks. Is the defendant doing an identical mark, or is it evocative in some way? Is it similar? How is it similar? How is it dissimilar? Courts have to assess that. Number 4, and this is often held to be the most significant factor within the confusion analysis, courts look to, is there any evidence of actual consumer confusion, i.e. actual members of the consuming public who confused the defendant's product or service with the plaintiff's because the trade dress looked the same and they just thought it was the same company. Number 5, the marketing channels used. Are they marketing in the same channels, or are they actually marketing in very, very different channels? Number 6, the type of goods or services being sold and the degree of care likely to be exercised by purchasers of the defendant's product. This is a really critical factor for trade dress, and as we're about to get into our discussion of automobiles and cars, it's a great place to think about this factor in the big picture and what it means. When it comes to buying, for example, a Ferrari, consumers exercise a great degree of caution, sophistication in their purchase. You don't just buy a $230,000 car at the checkout stand and make a mistake buying something that's not a Ferrari when you thought it was a Ferrari, right? That type of purchase and that type of product is one that then leans in favor of a conclusion that consumers exercise such a massive degree of care that they're not likely to be confused by a knockoff product. Contrary, if you're talking about chewing gum at the checkout stand of the grocery store that costs 99 cents, and you see a packaging that looks like the Wrigley packaging and you don't notice that it's not Wrigley's, it's cheap, it's inexpensive. Consumers aren't expected to use as much caution or concern in making the purchase, and so courts conclude consumers are more likely to be confused by similar product design that can lure them to make a purchase of what they think is Wrigley's chewing gum when it's not, because of a look and feel similarity right in the packaging. That's the example on the other end. Number 7, the defendant's intent in selecting the mark. Again, what we're concerned about here is, why did the defendant select this mark? Did they copy the trade dress of the plaintiff, lock, stock, and barrel, in order to siphon off the goodwill. If they did, that kind of leans in favor of the conclusion that there's probably confusion because it was benefit to taking the plaintiff's look and feel. And then finally, courts look to the likelihood of expansion of the product lines and whether the parties are competing in the same product line now or whether they're likely to be competing in different ones in the future. So with this, let's turn to our first example of automobiles, and we're going to start with Hummers. This is the case of General Motors versus Let's Make a Deal. It's at 223 F sub 2nd 1183. It comes out of the District of Nevada in 2002, and it revolves entirely around what you can see in the photograph there, that front grille of the Hummer. And if any of you are watching this right now, you may or may not see that grille and just know it's that iconic Hummer grille. You may know it because of the shape and design of the grille as opposed to seeing the word Hummer. Or maybe you have no idea and the only reason you know that's a Hummer grille is because you see the word Hummer there. This is the critical question in the trade dress case because General Motors actually registered that grille, that nose and grille front end of the Hummer with the Patent Trademark Office, and they got a grant from the Patent Trademark Office of that grille design being non-functional. Now, the defendant was a company called Let's Make a Deal. It was a used car lot out of Las Vegas. And what it also did, as well as selling its cars, it sold car kits that had a very similar nose and grille that people could then get to create the Hummer look. GM obviously was not happy. It filed a lawsuit in Nevada. It alleged it had spent hundreds of millions on marketing its trade dress in its various grille designs since the early 1980s. And I'm quite sure those hundreds of millions probably, the opinion doesn't unpackage it, but they were probably on the Hummer in total, not just the nose and grille obviously, but it spent significant millions of dollars marketing the specific grille design also. So General Motors sued and asked for a preliminary injunction, and the case went before the district judge, who then had to analyze these three factors we've been talking about: functionality, secondary meaning, and confusion. And so on the next slide, you can see on the first issue of functionality, the court concluded that that grille design was not functional. Now, what's really important here is the court looked at it and said, obviously there are some aspects of that grille that serve a function, i.e., there are openings in the grille to allow air into the engine, which you have to have. And so the idea of having a grille with openings has functional aspects to it. But what the court concluded is that the overall look and feel was not functional because there are 100 different ways at some level, right, to make a grille. You don't have to make a grille that looks exactly like the Hummer grille in order to make a grille and allow a car to intake air. And so the existence of so many competitive different grille designs yielded the conclusion for the court that therefore this was not functional and this particular design was a unique non-functional design. In other words, no one's at a competitive disadvantage because they have to make a grille look different. Now, the court also then concluded when it went to secondary meaning that yes, consumers do associate that grille and nose with a particular source. Here it was General Motors, obviously. And there was evidence that consumers did do that, and there was also evidence of intentional copying. And so as a result of that evidence and the evidence of a likelihood of confusion, the trial court granted a preliminary injunction, and the Let's Make a Deal folks had to go to the plaintiff and make a deal to try to get out of that case. And so that's the first example of Hummers. So now we move from General Motors, we move to Chrysler, and we move to the Viper. For those sports car fans out there, you may remember the Viper. This case is Chrysler Corp versus Silva. It's at 118 F 3rd, 56. It's from the First Circuit in 1997. So here you see the picture of the Viper there, and here you have the plaintiff, Chrysler Corp, suing the defendant saying, you, the defendant, copied our really innovative muscle car. We have spent $80 million to bring this car to production. It was sort of a really cool prototype back in the day, and it was a unique special car that had a special sort of look on the road. And what the defendant business was built around was building a car that they called the Mongoose. And the Mongoose was a car that was to sit on the existing chassis of, say, a Corvette. And so it was not a carbon copy, but it was very, very similar to the Viper. And unfortunately, the record is so old that I can't find for you a photograph of the actual mongoose. So if any of you happen to have a photograph, please send it to me so I can update this program. But nonetheless, it was the court concluded it wasn't a counterfeit in the sense that it was literally identical, but it was very, very similar and very, very evocative of that Viper look, the stance, the look and feel, the front end, the back end, that kind of the curved flares, the intakes on the side. And the idea was you buy this mongoose body that looks very similar to a Viper, you drop it on a cheaper chassis, and now you're driving around in something that looks like a Viper. So the district court concluded that the Viper had secondary meaning and was proper trade dress and was non-functional. But the district court concluded, even despite all that, the defendant's design was acceptable because when the court got to the likelihood of confusion analysis, what the district court judge here said is that no consumers would be confused, precisely because consumers knew they were not buying a Viper. It wasn't being offered as a Viper. It wasn't being passed off as a Viper. It was a mongoose. And so consumers, even if they saw it, they would know it's not a Viper. And so therefore, the district court concluded, because there was no consumer confusion, the fact that the car looked identical and the same didn't matter. And here what was animating the district court was its perception that really the root purpose of the Lanham Act and the core assumption of the Lanham Act is that we are here to protect against consumers being confused more than we are to protect companies in their creations and innovations within the trademark laws. So this went up on appeal to the First Circuit, as you can see on the next slide, but the First Circuit, reversed. The First Circuit reversed because it said the district court ignored all the evidence that post-sale, you just show it to general members of the consuming public, people thought they were the same car. And the First Circuit said this is highly relevant because this damages the Chrysler brand built around the Viper and the reputation. And so even if they weren't losing sales because of it, infringers, like Silva, who maybe they do a poor job mechanically, or that can detract from the consuming public's perception of that car being a good car, or it just makes them ubiquitous and available, and this otherwise rare sports car that very few people have and has that kind of cachet value being rare is no longer rare. And so what's fascinating about this case, and it's a great fault line to be aware of, and it pops up in the car cases in particular in trade dress, is this distinction between what is the purpose of the Lanham Act. And if you have jurists who either fall deeply on the consumer-only side, or you can position your case on that side if you need to, they're more likely to look at a very expensive car and say, no one's confused, no big deal. If you need to position the case more on the side of this is about goodwill and brand protection, which also ties into consumer confusion in the post-sale market, then you're more likely to get a favorable plaintiff side, trade dress conclusion of non-functionality. So here, a new trial was ordered, the case went back, and the case certainly ended after that and settled. Now we shift to Bentleys. This is the case of Bentley Motor Car Limited versus Matentagart. It's at 899 F Sup 2nd 1291, and it's from the Middle District of Florida in 2012. This is similar to the Viper case in that here you have Bentley suing the defendants on the basis that they were manufacturing what were very, very similar body kits to the Bentley that could transform an ordinary and inexpensive, say, Chrysler Sebring or Ford Mustang automobile into knockoff Bentley vehicles. And they were doing this by intentionally misappropriating the overall appearance and shape of the Bentley automobile. And on our next slide, you can see a Bentley on the left, and on the right, a converted Chrysler. Take a look. To my eye, they do look the same, and I could easily imagine myself being confused. What did the court conclude? Well, on the next slide, you can see the plaintiff argued that consumers are going to think they're Bentleys. We have to win. You're creating consumer confusion. The defendant took the position that no, I just simply on my own imagined a car that looked like this. I never remotely copied the Bentley. My idea popped out like this. And the defendant pointed to a number of material differences and also gave evidence that I never advertised this as a Bentley or a knockoff. But nonetheless, the district court looked at it and said, These features are non-functional. It's an ornamental look and feel for this unique car, Bentley. It's developed secondary meaning, and certainly there were confused consumers. And here's a very critical evidence pointer to track when you're litigating these cases or thinking about litigating them. Go look at social media and third-party comments on the similarities and record and save that data, because your experts then can look at it and make great use of consumer comments, maybe on Instagram or Facebook or blogs, where people are saying, oh yeah, that's a knockoff Bentley, it looks just like one. All those types of comments being made by third parties, although they're hearsay, obviously, your experts can rely on them as evidence of consumer confusion. And so it's very critical data to record if you're likely to be on the plaintiff's side and you see a knockoff out there and you start seeing that data. You want to go get it recorded before you sue the defendant, and the data may disappear. So Bentley won that case and the defendant was out of business. Now we get to Ford versus Ferrari. And here we have, again, the famous Ford Shelby Cobra on the left, and of course the famous Ferrari Testarossa on the right. And so we're going to start here today with the Ferrari Testarossa case. And this is reported at 944 F. 2nd, 1235. It comes out of the Sixth Circuit in 1991. And the basic facts are as follows. Ferrari began producing a car it called the Testarossa in 1984. By 1991, Ferrari had produced and sold only 5,000 of these Testarossas. It was intentionally limited, that is the production, in order to preserve exclusivity of the car. This is a black swan, basically, in the car world, right, in the 1980s. They were rare. And so the entire anticipated production of Ferrari Testarossas was continually sold out for the next several years, creating a huge waiting period to purchase one of about 5 years. And this is from 1991 when the opinion was published. The Sixth Circuit said a new Testarossa sells for approximately $230,000, which, you think about that, that's 1991. Today, I mean, that's a stunning sum of money. So what happened on the next slide, you can see, there again is a fiberglass kit car. This is called the Miami Spider. And that's the defendant's kit car. And it's a one-piece body shell that was molded from reinforced fiberglass, and then it could be bolted onto the undercarriage of another car, like a Chevy Corvette or a Pontiac Fiero, and those would be sort of the underlying donor cars. It sold for $8,500. And as the Sixth Circuit concluded, it was virtually identical. And if you look on our next slide, you can see, I mean, they really do look virtually identical. And the car on the right, which is the replica car, has that same kind of grille work on the side, the same sloped front end, the same lights and grille on the front. I mean, and the same, scooped back from the driver door to the back rear side of the car. I mean, it just looks like a Testarossa. You could easily think it's a Testarossa if you saw it. So the court went through the analysis, and let's look at the first one. And this is sort of a fantastic lesson on evidence in these cases on the plaintiff's side and how you want to, put your case together to build it. On functionality, Ferrari got designer testimony, and it got it from a man, Angelo Belli, and he had developed Ferrari's Grand Touring cars. And so Ferrari put him on the witness stand to explain that Ferrari chose its exterior car designs for beauty and distinctiveness, for that rare, unique look, and not for utility or function. And the court looked at that evidence and concluded that the shapes and the features, therefore, were not functional. And that is exactly how these cases get litigated. On the plaintiff's side, you want your design engineers and designers to be able to get up and testify that the look and the feel doesn't serve a functional master. It serves an ornamental master. So the court concluded that the design was non-functional based on that. The next slide takes us to secondary meaning. And here, what the court said is that as a starting premise, Ferrari's vehicles would not acquire secondary meaning simply because they were unique designs or because they were aesthetically beautiful. That's not enough to have secondary meaning, just to say, oh, it's beautiful. What you need to show is that design, be it a beautiful one, but that design has to be one that's instantly identified in the mind of the informed viewer as a Ferrari design. It belongs to a particular source or producer. And so here, again, there was fantastic evidence that Ferrari had put together as it built its case carefully. Pre-filing, it sent in some undercover operatives to go, chat with the defendants about maybe buying, one of these kit cars and whatnot. And the defendant said, quote, "Well, we put this whole body right on it and it just looks like a real car. I mean, they can't tell by looking. We build cars and sell the same car, reproduce it." That is completely damning evidence, obviously, that it was being copied precisely because Ferrari had secondary meaning, precisely because they wanted consumers to see it as a Ferrari. On top of that, Ferrari put together survey evidence, and so they showed photographs of Ferrari cars without any Ferrari logos on them, so it was just the look and feel of the body. Because remember, the trade dress is just this shape of the car. It's not the logos that identify Ferrari. So you take out the logos, show the photograph to people. 82% of the respondents said, "Oh yeah, that's a Ferrari product." So the court held it was valid trade dress with secondary meaning. Now here's what's fascinating on the next slide, likelihood of confusion. You look at the analysis of these factors and how they lined up, whether for the plaintiff or the defendant. Well, the first three lined up for Ferrari. It's a strong mark. It's a very unique trade dress. It's strong. The products between the two companies are completely related, and the similarity was nearly identical, the defendant's product. But the fourth factor, actual confusion. There was no evidence whatsoever. The defendant actually argued that similarity of products isn't enough. I mean, you have to show that there's got to be confusion as to the origin of the product. And the defendant argued that these replicas can't violate the Lanham Act because all the purchasers knew immediately that this is not a Ferrari Testarossa. It's $8,500 sitting on a Pontiac Fiero. And so, no harm, no foul. There's no consumer confusion. On top of that, the defendant argued that, we use different marketing channels. Ferrari advertises its cars in these sort of high-end retail dealerships, high-end magazines, et cetera, et cetera. We don't. Degree of purchaser care also favored the defendant. People who want to buy a Ferrari Testarossa don't accidentally buy a replica on a Pontiac Fiero. No evidence of likelihood of expansion. So you can see the marks, some of these factors on confusion line up for the plaintiff, some line up for the defendant. The Sixth Circuit held, nonetheless, Ferrari wins. But if you look on the next slide, there was a dissent. And here's the dissent. This is really fascinating. The dissent said, "I respectfully dissent because the majority opinion does more than protect consumers against a likelihood of confusion as to the source. It protects the source itself, Ferrari, against plaintiff's copying of its design, even if the replication is accompanied by an adequate labeling so as to prevent consumer confusion. The product of these errors is a remedy that provides defendant with absolute protection in perpetuity against copying its unpatented design." So here what the dissent is saying is what we talked about with the district court in the Viper case. Here you have another jurist saying, look, the whole point of the Lanham Act is to protect consumers, not companies in their unique designs. If the company wants its unique design protected against another competitor, it should get a patent. If it doesn't get a patent and it's only in the trade dress realm, then it should only have a remedy if consumers are genuinely confused. And so this is where we're on that spectrum of what the Lanham Act is serving fundamentally. So that's our Ferrari case. Ferrari won. Let's turn to the Ford Cobra case. Here we have, this is 251 F sub 2nd. This is from the District of Massachusetts in 2002. And it's a case based on this iconic Shelby Cobra. And Carroll Shelby, of course, developed this Cobra during the 1960s. And Ford went ahead and actually produced the car and registered some trademarks in the name Cobra. But the actual shape of the car was never registered. And by the late 70s, there were dozens of companies that were making kind of Cobra replicas. And one such company was called Defendant Super Performance International. And it began selling a rolling chassis in the mid-1990s. It was literally identical to the Cobra shape, even with the Cobra emblem sometimes. And so what happens is Carroll Shelby and the company, and Ford as co-plaintiffs sued Super Performance International. And on the next slide, you can see the original and the replica. And you can see, quite literally, the replica is identical to the original. Plaintiffs were unhappy, they sued. On the functional question, the court said, sure, the Cobra design is non-functional, just like the Ferrari. It's completely aesthetic in design. That shape of that car and all those, curvatures and shapes and whatnot. They don't serve functional masters. So it was held to be non-functional. Now, this is where we suddenly have a problem for the Ford Cobra that we didn't have for the Ferrari Testarossa. The Massachusetts court posed the following central question. Who's the source of the Cobra design? And the court said, this is a unique case in which Shelby appears to be the designer, but Ford's the producer. And so the court concluded that you can't have trade dress protection for designers who aren't actually selling the car in the marketplace, because it's the actual selling of the car in the marketplace that's impacting competition and consumer choice, and it's that entity that's the entity that's dealing with this look and feel. And so design patents and copyrights are really where designers should go if they can't fulfill this initial source requirement in secondary meaning. As we go to the next slide, you can see that the other problem that confronted Shelby and Ford in this case is that they didn't put together good survey evidence of the kind that Ferrari did. And that's not to say they made a mistake. They may just not have been able to gather the survey evidence to actually find confusion or secondary meaning, the way Ferrari did. And so what happened here is that they offered evidence, the Shelby company, they got a statistician at Pricewaterhouse who did face-to-face interviews with sports car hobbyists. But here's what the court said. Although the survey establishes an association between the Cobra design and Shelby, that is insufficient to support a reasonable jury in Shelby's finding. Rather, Shelby must prove that the primary significance of the Cobra shape in the minds of the consumers is to identify Shelby as the single producer. And here's when you get into the weeds and they looked at the survey evidence, that the district court here took it apart and said, yes, the expert said that 50% of the polled people associated the picture with a quote-unquote Shelby. But when the court looked at those survey results and sort of peeled the layers to the onion, what the court said is, the problem is those 50% responses, some said it's a Cobra, some said it's a Shelby Cobra, some said it's a Ford Cobra. And so what the district court here said is, that actually proves the very point, which is no one associates this with a single source. And so, in effect, the plaintiff's own evidence of secondary meaning undercut its very case of secondary meaning and really proved that people associated that design with different sources, and it was just this sort of scattered design that had been lost in the marketplace. So, as you can see on our next slide, there we have the picture of the Ford Shelby and the Ferrari, and in this race, unlike in the Hollywood movie you may have seen, in this race, Ferrari won and the Ford Shelby lost. And so, there are some big practice pointers that come out of this analysis that we've done of trade dress cases in car design. And they're really critical practice pointers for you as counsel who may be litigating a trade dress case. The first one revolves around how you focus your narrative, your case, your discovery, your depositions, your arguments, your written persuasive work, right? Your complaint even. How all of that is filtered through the prism of the Lanham Act being there to eliminate consumer confusion by ensuring that goodwill that exists in company products is not lost and taken by someone else. On the flip side, the practice pointer is there are jurists, as we saw in the Viper case with the district court who was reversed, and we saw it again with the dissent in the Ferrari case. There are jurists who feel when you're talking about very, very, very expensive products where there's a lot of consumer caution in purchasing, that there is a problem, there's this tension in the law between allowing companies to effectively get a perpetual monopoly on the design and shape of that car where you don't have confused consumers. And so you as advocates have to know what side of that Lanham Act line you're on so that you can build your case. The second practice pointer that came out, I think, of this interesting walk down car space we've been down is that you need good surveys, you need good survey evidence, and you want to make sure your evidence actually is good evidence that proves the point you want to make. The problem we saw for the Shelby company was that their surveys, the way they were conducted and the results they ultimately yielded that they were willing to use with their testifying experts, yielded actually a showing of confusion in the consuming public's mind as to who was the source, and so that undercut their case. In distinction, Ferrari was able to get survey responses that showed near universal recognition of that shape with the Ferrari car. And that's not to say that Ferrari had better lawyers than Ford in those cases. It's a function of different fact patterns and the difficulty of, 20 years, after the Shelby Cobra came out, and there had been other replicas trying to go into court even 30 years later, where the horses left the barn and it was too big an undertaking to then fix. Whereas Ferrari, when a knockoff, showed up on the Testarossa, immediately after the Testarossa was released, Ferrari was on it in litigation immediately and took those steps to preserve and protect its sort of brand identity, right, immediately. So those are the huge practice pointers that I think come out of the Ford and Ferrari case as we've walked down our exegesis today on intellectual property and cars. Now we have a pit stop, as you see on our next slide. This is our first little pit stop in the trade dress realm, and we're going to talk about Porsches and polish. And so here we're going to talk about intellectual property in cars and trade dress and trademark rights, but we're not dealing with car companies having their cars knocked off. So this isn't the situation of Porsche suing someone for making a replica Porsche. This is a different situation. Here what we confronted was a company called Liquid Glass Car Polish. And in May of 1997, in the Motor Trend magazine, they took out an ad. And it showed a provocatively dressed woman applying this liquid glass car polish to a Porsche 911 with the trademark Porsche prominently displayed on the car, the badge on the front of the car. And what the district court here held was that the reason that Liquid Glass chose to use a Porsche instead of the vast array of other cars and chose to clearly display the trademark Porsche was not, in this court's opinion, because it needed a mere prop, but because Liquid Glass wanted to usurp Porsche's reputation and strength and persuade consumers that Liquid Glass produces high-quality products. Stated somewhat differently, Liquid Glass wanted to cash in on the goodwill that Porsche has worked hard to create and maintain by aligning itself with Porsche. This was at 8 F. 2nd 398 out of the District of New Jersey in 1998. And as you can see there, this is another example of Porsche litigating the case on the correct fault line in terms of its goodwill, its brand, and why the defendant was taking the Porsche car and the emblem up close and filming that to show the polish working. Whereas what the court was saying is, in reality, you didn't need to show Porsche and its logo to show a piece of metal being cleaned. You could have shown a door that was just some nondescript white door and you would have achieved the same thing. The defendant's intent, in other words, was ill, and that's what hung up the court, and that's why the Liquid Glass Car Polish Company never again made such an ad. Pit stop 2, which is our final pit stop today, is of course Lamborghini. How can you do an intellectual property program on exotic automobiles and not talk about Lamborghini? Well, here we're dealing with Lamborghini versus a Las Vegas restaurateur. On the left, you can see what I'm quite sure you all know is the famous trademark of Lamborghini with its sort of that unique shaped badge, the bull sort of head down, and then Lamborghini written across the top. Well, Lamborghini was unhappy one day when it learned that there was a company in Las Vegas called Del Toro, Spanish for bull, that was selling apparel and accessories that had this sort of imitation Lamborghini logo on it. And there you can see it on the right, Del Toro with a bull. And here it's just the head of the bull. And it's a slightly different, angle of the head and whatnot, but it's still a bull and it says Del Toro. And Lamborghini was unhappy because, you have apparel and accessories being sold without permission from Lamborghini on its, trademark logo. And on top of that, it was a restaurant, an Italian restaurant that was, which also had then exotic cars and showrooms attached to these Italian restaurants. And so at first out of the gate, Del Toro said, we're a restaurant. No one's confused into thinking we're associated with Lamborghini. We're just a restaurant and we have some fancy cars and some apparel and it's just a bull. And, a bull is, a bull. What's the big deal, right? Turns out it was a big deal. And so what happened very quickly after Lamborghini sued was a near immediate settlement with a stipulated injunction that the restaurant would never again engage in any such conduct and use any such logo in its restaurant, on promotional materials, on clothes, anywhere, even on business cards. And so That is our second pit stop on Lamborghini, which closes the loop on the exotic cars today, I think. So here on our final slide, you can see our conclusions. The first one is that trade dress is a really potent remedy for a plaintiff to protect non-patented, non-functional designs in the look and feel of products or packaging. Whether you're in cars or not, it really is a potent remedy to consider using. All too often, plaintiffs and entities may not have got a patent because they missed a deadline or they didn't have the money or the resources, so they lack a patent. But they may still have protection in that product design and packaging and aspects of it that even if, the grill, for example, in the Hummer case, even if that had functional components to it, there were also ornamental non-functional components. And so you have to think about trade dress as a protective remedy if you can show secondary meaning and consumer confusion. And because trade dress rights live forever, so long as you still continue using that trade dress, you have a very, very potent remedy in your arsenal. You should also consider, depending upon the entity that you're representing, whether you want to try to register the trade dress on the front end. And remember what I talked about earlier, there's pros and cons. The pros being you have prima facie presumptions of secondary meaning, you've established it, you don't have to prove it anymore. The cons are, if you go for that, if you run that gauntlet before the Patent Trademark Office and lose, you're forever out of luck and you don't even have leverage over a defendant down the road. The second one is that you need confusion-related evidence, secondary meaning-related evidence, and so what you really want to keep is records of what consumers are saying to you, to third parties in social media. Just be aware of it and watch it and tell your clients, record it, track it, screenshot it, print it, Adobe PDF it, whatnot, so that you have it, because this feeds into the third point, which is, in these cases, expert evidence can really be crucial. Expert evidence on functionality, secondary meaning, it moves the needles in terms of how the cases come out and come down. And the final conclusion, specifically for cars, is that if your clients want to make replica cars, you can tell them now that it's almost impossible to copy a car design and win. Car designs find protection almost universally in the district courts within the realm of trade dress law. Whether it's, Ferrari, Hummer, Lamborghinis, they're all going to find this protection. But you can also tell your clients if you want to make a Ford Cobra Shelby, they may well be able to under the replica laws that seem to have attached to that car since it couldn't show secondary meaning. So what you should recognize, though, is that at the same time, this is not a slam dunk. If you find yourself in the wrong forum with the wrong set of judges who feel that you're pushing the Lanham Act outside of the bounds of really protecting against consumer confusion into creating a backdoor patent, you can run into trouble. So thank you very much for watching today. I hope you enjoyed this program of Ford and Ferrari, and have a good day.